Twitter, YouTube, and on Facebook as well. So please bear in mind that the events that are going to be happening and unfolding here are going to be live. As a standard procedure, we request everyone is going to participate, and especially people that are going to use the video, to please ensure that you are properly framed. I can already see that there's a gentleman who's not properly framed as well. Please make sure that the framing, as you see, as you're looking at yourself in the video that is appearing on the screen, the video of yourself, make sure that your shoulders are appearing on the screen, as you can see how my picture has been framed, because it's important, because when we post your name underneath your picture, it usually appears on this part of the picture. So if you are slouching like this, your name might end up appearing on your face or some parts of your body. Now, for us to be able to see the entire your entire face, please ensure that your shoulders are in the picture. I would request, I see that there's a gentleman called Theogene Rajao Narvido. We can only see your head, sir. Please ensure that we can see your face and the shoulders, which is a standard procedure. The name is going to appear on this side, and there might be some other taggings that are happening on the screen, which is very important when you do the framing, to please ensure that your shoulders appear in the picture. I can see the SG has got the perfect picture there, and also apologies, I won't even try to pronounce the name, but the lady in the yellow t-shirt, in the yellow top, sorry, very much, thank you very much, ma'am. That and you, your Royal Highness, I can see that you properly framed. We just need you to move a little bit back so that the shoulders can appear a little bit more for the TV. Thank you very much. Thank you very much, Mr. Jean from Madagascar. We can see you properly there. Thank you, sir. I can see you properly now. Yes. Thanks. Over to you, Chairperson.
Thank you very much, Modise, for those announcements. And we can clearly see each other now. It's 10:03, and now we must officially start our meeting. As I said, I'm going to be the Director of Ceremonies this morning. I am Sheunen Kurasha. I'm the Program Manager for Democracy and Governance, and also responsible for parliamentary business at the SADC Parliamentary Forum. Let me observe the protocol by recognizing the presence of Her Royal Highness, Madame Boyemo Sehoma. She is the Secretary General of SADC Parliamentary Forum, but today I'm sure she's wearing another hat, seeing that she's in the midst of fellow royal people. I also wish to recognize in a special way our guest who will deliver the keynote address, Her Royal Highness Ramanatsoa from Madagascar. Greetings, Madam. How is Tana? Thank you very much. I also wish to recognize Professor Ezra Chitando from the World Council of Churches Southern Africa, who will deliver our closing, concluding, and solidarity remarks. I recognize that we are in the midst of distinguished traditional leaders and religious leaders, some that are drawn from parliaments. I see senators and various distinguished leaders from this sector. We wish to recognize and welcome you in a very special way to this session. Allow me to also recognize the legal draft person for the SADC model law on gender-based violence, Madame Eva Jala. members of the media, fellow staff of national parliaments and SADC Parliamentary Forum, distinguished guests and ladies and gentlemen. This morning, we meet on the occasion of consultations with traditional leaders and religious leaders regarding the SADC model law on elections. May I request host to allow me to share the consultations that SADC Parliamentary Forum is making with stakeholders on the model law must be understood within the context of the mandate of SADC Parliamentary Forum to develop model laws to assist member states to bridge legislative and policy gaps at the national level against regional and international commitments on various issues of regional interest and concern. And in line with its constitutive mandate and as a parliamentary body, SADC Parliamentary Forum has held various consultations with the stakeholders regarding the model law. And in this regard, I wish to share with the House some of the consultations that we have undertaken. I'm failing to upload the calendar for consultations. Are you able to share it from your end? Right, I managed Ronald. I'll be fine. So just to put into context the consultations, I'm sharing with our distinguished participants the various consultations we have held with different stakeholders across the SADC region in the various member states. So in the context of the consultations, we have met with the media, we have consulted with SADC lawyers, we've also held consultations with human rights commissioners, ombudspersons. We've consulted with civil society organizations, judges, jurists, and judicial officers, the youth ministries of gender and departments of gender of SADC member states, the police, parliamentary committees at national level that deal with issues of gender, children's rights, legal affairs, police, and justice. We've also held consultations with legal draft persons from the ministries of justice and from national parliaments. We have met with SADC PF standing committees and the regional women's parliamentary caucus. We have consulted with the UN agencies and donors. Today we meet with yourselves, traditional leaders and religious leaders. The consultations will continue with a meeting tomorrow with magistrates from SADC member states. We shall also consult with other regional and international parliamentary bodies, such as the East African Legislative Assembly, ECOWAS Parliament, Pan-African Parliament, etc. We will consult with prosecutors from SADC member states, legal aid officials from SADC member states. You can see how extensive the consultations have been, the intention being to make sure that there is ownership, to make sure that when the model law has been adopted, it is anticipated by stakeholders, and they will be able to make use of it. In the same vein, for traditional leaders, being the custodians of traditional norms and values, we see you as an important stakeholder. Hence, this meeting with yourselves. Allow me, as I bring us closer to the official opening session, to just briefly share the program overview. So this morning, we will start off with welcome address by the Secretary General, Madam Boemo Sekoma. We will also have our keynote address, as I already said, from Her Royal Highness Princess Mianda Ramanatsoa from Madagascar. We will then invite the legal drafter to present the draft model law, following which we will then have deliberative sessions. And after the deliberative session, we will conclude with solidarity remarks from Professor Ezra Chitando from World Council of Churches, Southern Africa. At this juncture, allow me to have the honor of inviting the Secretary General, Madam Sekoma, to deliver a welcome address. Over to you, SG.
Director of Ceremonies, Mr. Shaunene Kurasha, thank you for those welcome remarks. And thank you for sharing with our constituency the roadmap that has been engaged in regarding these consultations. Allow me, sir, to recognize and welcome Her Royal Highness Princess Mahinta Ramanatsoa from Madagascar. Also to recognize Professor Ezra Chitando from the World Council of Churches of Southern Africa. Allow me also to welcome our senators from the various parliaments of SADC and those from the House of Chiefs from our respective countries. Also to recognize our revered and committed, esteemed draftsperson, Ms. Eva Jala. I also wish to recognize technical working group members who are here present, members of the media, and our valuable staff of SADC Parliamentary Forum and SADC National Parliaments. Bonjour, bon dia, good morning. It's a unique honor for me to welcome you all on behalf of the SADC Parliamentary Forum to this important consultative meetings. I address you this morning as a layperson in matters of theology or tradition. I hope that in the process of our deliberation, you'll consider me as an ordinary citizen of the region who's occupying the position of the Secretary General, therefore your servant at most. I consider this a very rare privilege to address you as my leaders and hope you'll find it in your hearts to conciliate my views with yours, should there be any discrepancy. Our Royal Highnesses, distinguished participants from religion and tradition, as you may be aware, this consultative meeting is being held in the margins of the development of a SADC model law on gender-based violence, which has necessitated us to reach out to as many gatekeepers as possible, including yourselves. Needless to say that the consultations would have been incomplete without the august participation of traditional and religious leaders. Being mindful of the crucial importance of faith leaders in the gender-based violence discourse, it was thus imperative to engage you on the road to progressive norms such that your valued input is comprehensively garnered at this stage. Honorable participants, distinguished religious leaders and traditional leaders, the forum is aware that your input as traditional leaders and traditional leaders is necessary to strengthen the social fabric of the SADC region. The SADC Parliamentary Forum has always prompted broad consultations on gender equality and sexual reproductive health and rights, whereby there is ample room for consultations with religious and traditional leaders. And this has been the norm since the inception of the forum, as the case may be. Therefore, the SADC model law on gender-based violence should be underlined as an instrument that will bring together a milieu of international best practices on gender-based violence legislation to the shore of the SADC region. And this model law is specifically tailored and destined and are customized for the SADC context and beyond. In this regard, we are aware that members of parliament need to work in close tandem with religious and traditional leaders to ease the adaptation of the legal provisions to the local context. Honorable traditional leaders and religious leaders, I believe you'll concur with me to find that the legal provisions concerning gender-based violence are mostly in harmony with religious and traditional values. Where there are discrepancies, we will be open to discuss about them. And we indeed require your immense wisdom in this regard, particularly on the fields of your experience, to help us rationalize the provisions in view of finalization of the SADC model law. During the presentations that you'll receive very soon on the SADC model law on gender-based violence, you will find that the mainstay of the model law consists of an unflinching compliance with human rights that are generally accepted internationally in global instruments, as well as in the African Charter on Human and People's Rights. To cite but a few, the gender-based violence model law is premised on the human rights to physical integrity, the human right to health, the human right to life, and the protection of the individual from torture and inhuman and degrading treatment. I believe our religious leaders and traditional leaders will agree with me when I say we are all born in the image of God. We are all God's children and equal in his eyes, and from whence the idea of human rights comes. It follows, in my view, therefore, that an injury to one is an injury to all. And therefore, the consultation is broad enough to encompass this principle and for us to look at mitigation measures. In a spirit of Ubuntu, the forum is mindful that shared religious and traditional values constitute the foundations of the notions of Pan-Africanism and the friendship, unity, and solidarity that exists between member states of SADC, as well as from member states of the African Union. Religious and traditional beliefs, irrespective of faith or religion, all point towards peace, justice, and freedom of the individual from torture and inhuman and degrading treatment. All religions and traditions of the SADC region want people to be safe and to feel safe whether at home or in the workplace. Besides, it is only when people feel safe about themselves that they can calmly and peacefully pursue their human right to freedom of religion and conscience. At the same time, the SADC model law on gender-based violence is gender neutral. That is, in simple terms, it covers both acts made by men on women and women on men. The model law will apply without discrimination based on sex, race, religion, gender, or political opinion. This August House will agree that this is why we firmly believe that the SADC model law on gender-based violence would also speak to the values preached by African religious and traditional leaders, and there will be no difficulty for the acceptance and assimilation of the gender-based violence model law at the national level. Distinguished religious leaders and traditional leaders, on this note, I'd like to appeal to your leadership skills within your respective communities and religious groupings to encourage adults as well as youth to do away with the taboos that contribute to the promotion of gender-based violence. For instance, within a marriage, whether it is a civil or traditional marriage, a spouse may not report gender-based violence due to the fear of being stigmatized by society. The answer to this predicament is certainly not to silence the aggrieved spouse who's suffering from atrocities, but instead to ensure that when gender-based violence reports are made, there's an adequate level of confidentiality that allows authorities to take action without the matter being widely talked about and put into discomfort or shame the parties involved. There are indeed competing interests here in trying to preserve the sacrosanct relationship of marriage and at the same time eradicating gender-based violence in modern contemporary Africa. In this respect, the forum does not have all the answers to the questions that may arise, simply because to make things work and to eradicate gender-based violence, everybody has to play their part at the appropriate time. It is indeed impossible to forecast every scenario that may occur in gender-based violence context, although a robust framework can be put in place through the model law, and I'd like to applaud our legal drafter, Ms. Eva Jala, who has ably demonstrated and looked at every avenue that would put us at ease in beginning to domesticate the provisions in the SADC model law. This is why the role of religious and traditional leaders are so important, since you are the implementers of positive change in society. You are the ones who are on the forefront to eliminate stigmas and work with authorities to make sure that the law is respected and the safety of individuals are ensured. You are also the ones who make public speeches to large groups of followers, and they trust you and your wisdom. You wear multiple hats as preachers, as peacekeepers, and also as educators and preservers of our culture and conscience. Educating individuals on gender-based violence is as important as implementing the gender-based violence model law itself, since without education about the law and what it protects, the status quo will remain forever in our society. Distinguished religious leaders and traditional leaders, before I end, I would like to say a few words about the model law on GBV as a regional instrument that awaits domestication in member states. While the model law provides for a benchmark or a gold standard that can influence the drafting style of SADC national parliaments, as well as the content of national laws or bylaws, there will be a measure of contextualization and further adaptation that will occur at the national level when the GBV law or amendments to the law are enacted by parliaments. So this is not a one-size-fits-all, and it has not taken on board every single issue that is in line with GBV. This is therefore a request to yourselves as religious and traditional leaders here today to keep an eye on GBV legislative reforms at national level and to contribute abundantly to local reforms that are in line with gender-based violence model law. While your wise input is required today, your guidance and contributions will be further required in consultations made at national level at the appropriate time. When such legislative opportunities will arise, we bank on you to put your best foot forward. We have what we refer to as sexual reproductive health and rights researchers who are based at national level within our parliaments in some countries. They will be valuable for you to engage with for further streamlining and contextualization to befit the domestication realm. Having made the above remarks, I wish to thank you again for your attendance today and wish you all a pleasant season. May God bless you and may you have an important engagement that you find valuable, having taken time away from your valuable engagements. I thank you, Director of Ceremonies.
Thank you very much, Secretary General, for those words of wisdom in your welcome remarks. Indeed, we feel welcomed, and I'm sure I speak for everyone. I can see smiles appreciating the words from the Secretary General. Indeed, our traditional and religious leaders are like our campus in most of our communities. They play an important role as the guardians of culture, but also in facilitating access to justice for most of our communities, and as such, they are an important player. At this juncture, it is now my pleasure to invite our guest of honor who will deliver a keynote address, as I indicated earlier. It's none other than Her Royal Highness Ramanatsoa Mihanda Ramanatsoa. I always make sure that I pronounce these words, the Malagasy language, very carefully. In my first time in Madagascar, we arrived to a city called Antananarivo. Then the locals told me, you can say Tana. And we were having a meeting with former presidents whose names were equally quite long, but I also made an effort to pronounce them so I would be able to associate with Malagasy people. So I'm honored to have the opportunity to be able to show off my Malagasy, a bit of my Malagasy, because of that experience. So, Honorable Royal Highness Ramanatsoa, we give you the floor to address us. Thank you so very much.
Bonjour à tous. D'abord, je ne suis pas la reine. Madagascar est une république et je suis la princesse Yanta Ramanantsoa et non pas la reine. Merci de me donner la parole. Madame la secrétaire générale du Forum parlementaire de la SADC, Duemo Sekoma. Monsieur le professeur Ezra Chitando du Conseil écuménique des Églises, Afrique du Sud. Honorable leader religieux et traditionnel. Madame Eva Jala, expert désigné à la rédaction de la loi type de la SADC sur la violence basée sur le genre. Distingués collègues et participants. Avoir été choisi pour prononcer le discours d'ouverture à cet événement où le Forum parlementaire de la SADC consulte les leaders religieux et traditionnels sur l'élaboration de la loi type concernant la violence basée sur le genre est un honneur. Au nom des leaders traditionnels et religieux de la région de la SADC, je souhaite exprimer tout particulièrement notre reconnaissance à Madame la secrétaire générale du Forum parlementaire de la SADC pour nous avoir délibérément inclus dans ces consultations. La pandémie de la COVID-19 nous oblige à changer de paradigme en replaçant l'être humain au centre de nos préoccupations. Quel est le monde idéal que nous imaginons pour nos enfants et petits-enfants? Et en quoi chacun de nous qui avons le pouvoir d'influencer pouvons contribuer à sa construction? Ce monde est un monde avec du sens, au sein duquel les politiques prennent conscience qu'il ne peut y avoir de développement économique sans développement humain. Le fonds culturel commun que nous partageons en tant qu'Africains devrait nous pousser naturellement à concevoir un cadre qui garantit à chacun, et surtout aux membres les plus vulnérables de nos sociétés, la protection et l'accès à leurs droits élémentaires. Car un droit qui n'est pas respecté est une forme de violence. La loi type de la SADC sur la violence basée sur le genre est donc une étape importante de ce processus. Elle met à disposition des États membres les outils et instruments législatifs internationaux et régionaux pour faire progresser les lois nationales et mieux coller ainsi aux réalités et à l'évolution de leur pays. Une loi protégeant les femmes et les jeunes filles de la violence basée sur le genre a été votée en 2019 à Madagascar sous l'impulsion de la Première Dame, que je remercie ici publiquement. Cette loi très attendue a mis des mots sur les réalités que vivent les femmes et les jeunes filles, notamment sur les pratiques de violence sous toutes ses formes. Actuellement, l'interruption thérapeutique de grossesse trouve un écho de plus en plus grandissant au sein de la population et constituerait, bien encadrée médicalement, juridiquement, professionnellement et éthiquement, une avancée réelle en matière de protection de la vie, de l'intégrité corporelle de la femme et de son droit à disposer de son corps. En tant que chefs traditionnels et religieux, nous sommes les gardiens du droit et des normes coutumiers dans la plupart des communautés, ce qui garantit une certaine qualité au lien social. Ce combat contre la violence basée sur le genre n'est possible.
This fight against gender-based violence is only possible if we join forces, men, women, boys, girls, tradition and religion as key towards modernity. In order to put a balance in society, leaders, may it be traditional and religious, need to be informed in order to help their community as this SADC model law is making it possible. In our region, many women and young girls are victims of violence without hope of being helped by police, social workers, or the legal system. sometimes because of location, sometimes because of infrastructures, many times because of economic reasons. And at that moment, traditional and religious leaders play their part in being mediators for these young girls and women to the society. The SADC model law is encompassing every thematic area and especially the status of victim in order to go towards rehabilitation. It allows young women and girls to have equal access to opportunities, to resources, because they are key to a sustainable development for the region and for Africa. Let me share my belief. The engagement of traditional and religious leaders is needed in this fight against gender based violence because they live in the midst of these communities. They are every day in contact with the population and can reach thousands of people. We therefore need to optimize their role in the implementation of the SADC model law. Nowadays, we have seen the growing visibility of women in the religious and traditional circle in order to help women and young girls in the fight against GBV. It is also needed and required to mobilize all these women and young girls in this fight within communities. And in conclusion, let me repeat what Ms. Boemose Homa said. The implementation of the SADC model law against gender-based violence shouldn't be an end in itself. It should just be the very first step in our fight against gender-based violence in our countries. As traditional and religious leaders, we are ready to work hand in hand with SADC and other stakeholders in order to implement the SADC model law in each and every member states so that our community may enjoy their rights. Madam Secretary General, dear colleagues, this is a date with history. And with these words, I officially declare open this consultation on the SADC model law against gender-based violence. I wish you fruitful discussions and deliberation. Thank you for your attention.
Thank you very much, Your Royal Highness, for those words of wisdom, of encouragement. The clarion call has been heard. The need to make sure that traditional leaders who live in the communities and witness incidences of gender-based violence are able to facilitate redress in the face of the violation of human rights of individuals, women and girls. The fact that the model law should and is not the end, but the beginning of work towards kicking out GBV within the SADC region, and also the important role that women leaders are playing as traditional leaders, as religious leaders, to ensure protection of women, access to rights in their communities. Thank you very much. We really appreciate your keynote address and your clarion call for action. Indeed, post the adoption of the model law, we, SADC Parliamentary Forum, shall continue to call upon traditional leaders, shall continue to work with traditional leaders and religious leaders to make sure that women do enjoy the full menu of rights and do not continue to suffer the scourge of gender-based violence. At this juncture, I wish to advise that the presenter for the draft model law is Miss Claire Msonda. She is the Director for Corporate Governance at SADC Parliamentary Forum. She will perform this onerous task on behalf of the legal drafter. So allow me to invite Madame Msonda to take the floor as we move to the next session. Thank you very much.
Thank you, Mr. Moderator. I hope I'm audible.
You are audible.
Okay.
And visible.
Thank you.
Most welcome.
Good morning to all the Royal Highnesses and the esteemed religious leaders that are in attendance. I think I've been introduced. I'm not the legal drafter, but I will endeavor to present the model law. There are very big shoes to fit in, but I'll make my best efforts just to highlight some of the key provisions and principles underlying the model law on gender-based violence, the draft model law. I will try and share my screen, but if I fail, I'll try and request, I'm not sure if all the participants can see my screen. The computer tells me they can see it.
Now we can see your screen.
I hope you can follow. Okay, thank you very much. We'll begin from.
Apologies, Claire. At the bottom of your right corner,
yes.
Can you click on the presentation icon? Just next to the 50%. Okay, just up next to the onto your left. That's the icon. Yes, ma'am.
Okay. Is that okay?
That's perfect.
Is that okay? Are we okay, IT?
Yes,
okay.
we are okay.
All right. I hope, how will you be able to move it for me? Because I'm not sure I can. Okay, so it's fine?
Yeah, you can move it.
Okay.
Yes.
Okay, sorry about that. I'm not very good with ICT. I have to really improve. So the SADC model law on gender-based violence is a guiding tool. It has been developed as a guiding tool, which seeks to guide member states in developing effective policies and efficacious laws on gender-based violence. It is not designed in the exact style and form as legislation in SADC member states, but it is designed in such a way that it will communicate clearly the policy content and recommendations on best practice legislative provisions for inclusion in an efficacious national GBV law. So it will be a useful tool for member states, and it will provide the following. It will provide guidance on the scope and content of GBV provisions to be made in national GBV laws. It will encourage national legislatures to enact laws where these do not exist, or where they do exist, to ensure that they conform to the principles contained in the model law, and to review such laws and enact relevant laws that conform. There's some noise. I'm not sure if it's. I don't know if you can hear me. It's okay now. The model law is also expected to provide support to national laws during implementation stage, where gaps still exist. It will also act as a yardstick to national policy analysts, legislators, and implementers as to best practices in dealing with GBV. That is at various stages of dealing with GBV, because there are different actors who are involved in dealing with GBV, as you may appreciate. It will also help to reinforce a commonality or a regional approach in dealing with GBV laws, measures, and strategies in order to help eliminate GBV. To be a stimulus for debate, awareness, and advocacy. What is the rationale and objectives of the model law? It is expected to be a governance tool to assist member states to develop and enact national laws on GBV, or revise existing laws or reform existing laws in order to meet international, continental, and regional commitments relating to human rights, and more specifically, international instruments on gender-based violence. The underlying rationale is that there is need to protect victims and probable victims of GBV, to punish perpetrators, and to ensure that human rights are upheld in accordance with international, continental, and regional standards and requirements. GBV, by definition, covers domestic violence, sexual harassment in the workplace, human trafficking, and sexual and emotional abuse, and economic violence, just to name a few. And this is the definition that is contained in the model law. When referring to GBV, the discussion is actually not just about an act of violence, it's also about education and prevention, as well as victim assistance. So this means that the provisions of the model law actually try to be quite comprehensive to cover all the different stages and areas of GBV, because GBV can be quite pervasive. GBV not only has terrible effects on the victim, but it impacts negatively on society at large, with serious social and economic consequences. Therefore, it's a national issue which requires drastic national interventions through the highest tool of governance, the law. As you know, the law normally comes with the enforcement powers, and because of that, it has the ability to actually deal with big areas of concern, social problems such as gender-based violence, and it is in fact the highest tool of governance in that regard. GBV is an affront to human rights at the same time, and there's a UN definition that gender-based violence is any act of gender-based violence that results in or is likely to result in physical, sexual, or psychological harm or suffering to women, including threats of such acts, coercion, or arbitrary deprivation of liberty, whether occurring in public or private life. At the same time, the SADC definition of GBV, which is similar to the UN definition, is that all acts perpetuated against women, men, boys, or girls on the basis of their sex, which cause or could cause them physical, sexual, psychological, emotional, or economic harm, including the threat to take such acts, or to undertake the imposition of arbitrary restrictions on or deprivation of fundamental freedoms in private or public life in peacetime and during situations of armed or other forms of conflict. So you can see that these definitions are actually all encompassing and try to cover all the probable forms of GBV. So in terms of the process of developing the model law, there was a kind of a scan taken of the legal landscape in the SADC region, and some inadequacies were identified in the national laws on GBV in the SADC countries, SADC member countries. So although the majority of the states actually do have laws in one form or another dealing with forms or components of GBV, they do not seem to be stemming or eradicating GBV. So this pervasive challenge continues despite the existing legislation in the SADC member states. So most of the legislation in the member states have certain loopholes or lacunae in the legislation, which because they lack scope or content, they are fragmented, they're inconsistent, in conflict, in allocation of, they create conflict actually in allocation of mandates, They can be ambiguous sometimes and generally vague as to meaning, privilege, entitlement, or right. There was also the challenge of lack of adequate access to justice provisions in the legislation. And because of this, the existing laws, were not able to enable and capacitate various players in the criminal justice and administrative systems to prevent, receive, investigate, attend, prosecute, and decide on GBV cases and enforce decisions and protect victims of GBV. In the existing legislation, there's also a lack of adequate compliance and enforcement measures, and that makes the laws inefficacious and they do not have the impact that they are intended to have. There's also a lack of adequate provisions to ensure sufficient and sustainable resources. So as you may appreciate, gender-based violence, tackling gender-based violence requires some substantial resources and on a sustainable or ongoing basis. Unfortunately, the provisions of the existing legislation do not actually cater adequately for this. And this results in lack of administrative and financial capacity to deal with GBV. There's also the lack of provisions acknowledging and addressing the nexus between statelessness and gender-based violence. So in our region, it was found that during the scan that I talked about to check the legislative landscape, it was found that statelessness actually gave rise to GBV. A lot of stateless people were subjected or became victims of gender-based violence on the one hand. And also forced migration has a relationship to GBV on the other hand. There's also a challenge of lack of inclusion of asylum seekers, migrants, and others on the move, as well as stateless persons. So in most of the legislation in the SADC member states does not cover those individuals who fall into those categories, yet they are existing and they live in these countries in the region. In terms of the national legislative and institutional framework, currently the issues related to gender-based violence in the SADC member states are regulated and managed by various ministries and statutory authorities with complementary support from the private sector, especially civil society. In most member states, there are no independent single regulators or management units dealing with matters relating to or impacting on GBV. And this includes the institutional frameworks. The existing ones include gender commissions, prosecution authorities, legal aid services, women's clinics, the police, victim support units, the judiciary, civil society, and workforce and institutional-based units. But for effective and efficacious handling of GBV cases, there is need to have legislative and institutional frameworks that provide adequate measures, strategies, programs, and interventions to deal effectively with GBV, including adequate capacity building of critical role players and stakeholders for effective and sustainable prevention, monitoring, and management of such cases. It's also important to ensure that the law provides an adequate institutional framework for engagement of all players who regulate, manage, and are affected by GBV by providing for a clear system of coordination, communication, and collaboration among all players when dealing with GBV cases with clear lines of responsibility. So it has been observed and noted that coordination is actually a challenge in terms of the different players who are involved in the process of handling GBV cases. So there's need for the regulatory and institutional frameworks to be clear and certain on issues such as the extent of regulatory and investigative powers, functions and duties of key role players, procedural requirements, access to justice, coordination, communication and collaborative issues, enforcement and compliance mechanisms, and management of infrastructure facilities, just to mention a few. The victims of gender-based violence and the private sector involved in providing advice, assistance, and protection to victims of GBV need assurance that regulatory state authorities have the necessary autonomy, the power, and the capacity to act fairly, transparently, and decisively when responding to GBV cases. So it's quite important to have a robust regulatory and institutional framework. The gender-based violence model law, the SADC model law on gender-based violence, actually seeks to establish a paradigm shift in the legislative system for gender-based violence. And in that regard, it is hoped that national laws on GBV would aim to provide a four-pronged approach towards achieving the paradigm shift in the legislative system for GBV. And this, I'm going to itemize the four-pronged approach. Firstly, the legislative landscape must provide a human rights-based approach to GBV laws that address the root causes of GBV and allows for inclusion of all marginalized persons without documentation, as well as migrants, and they ensure that such approach is actually applied by all respondents. Secondly, it must interface all concepts, rules, principles of access to justice to promote seamless connectivity for efficient handling, investigating, prevention, prosecution, protection, and enforcement of all GBV cases. So there are different stages at which in the process of handling GBV cases. And all these need to interface and use the same principles, the same concepts, and they ensure access to justice. And they must be, seamlessly connected. The legislation must also introduce, the model law also seeks to introduce innovative methods to deal effectively with GBV. For example, in these times of COVID, I think statistics show that gender-based violence is on the rise during this time of COVID for various reasons, which may be a discussion for another day. So there is need for legislation dealing with GBV to actually be able to deal with the emerging issues and emerging trends in the area of GBV. So the model law also seeks to ensure adequate information and financial resources are provided for intervention, prevention, protection, enforcement, regulation measures that will work, be maintained, and be sustainable. I think I mentioned earlier that in order to effectively handle cases of gender-based violence and achieve some kind of progress towards elimination or reduction, at least, financial resources are required. And the model law seeks to ensure that member states actually make provisions for such resources to be available for that purpose. Then on the issue of constitutions of member states and human rights, this has been taken into account in drafting the model law. And so if member states have to adopt the model law, either in part or wholly, they would have to take into account their constitutional provisions in their specific nations in the drafting or adopting or adapting and enacting the content of the GBV model law into their national laws. So the principle of intra-vires and outer-vires are applicable to primary and subordinate legislation, and it has to be observed by national drafters. Most SADC member states have bills of rights, a Bill of Rights embedded in their constitution, which, although it may not be comprehensive, most of these bills of rights closely follow the human rights spelled out in the Universal Declaration of Human Rights. And because of that, international human rights instruments also, which provide an agreed set of human rights principles and standards and establish mechanisms to monitor the manner in which human rights and freedoms are implemented, ought also to be taken into consideration in drafting or adopting the model law into the national legislative framework. The other human rights treaties of the UN that must be taken into account include the following: the International Convention on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of all forms of racial discrimination, Convention on the Elimination of all forms of discrimination against women, Convention against torture and other cruel, inhuman, and degrading treatment or punishment, the International Convention for the Protection of All Persons from Enforced Disappearance, the International Convention on the Protection of Migrant Workers and Members of their Family, the Convention on the Rights of the Child, the Convention on the Rights of Persons with Disabilities. All these are actually instruments that the model law draws upon in coming up with the precepts and principles that it contains. Sorry. And the model law also attempts to restate some of the human rights that directly impact on gender-based violence. These are in no way exhaustive, and the drafters of national legislation are expected to endeavor to summarize all their states' obligations at international level, to analyze them in the gaps in national laws where these exist.
Excuse me, Madam Sonda.
Yes.
ICT, there is a bit of feedback. I don't know whether it's from Mrs. Sonda or from another source.
I don't know, I can hear it also.
ICT, could you assist, please?
Can you still hear it, Corresa?
Yes, there is a bit of feedback. There was an echo, a bit of an echo, and also some sound, which is interrupting the presentation.
Everybody's muted.
Okay, so check if it's coming from Mrs. Msonda and assist. Proceed, okay. Mrs. Msonda.
So the GBV model law also attempts to restate some of the human rights that directly impact on GBV. These are in no way exhaustive, and the drafters of national legislation are expected to endeavor to summarize all their states' obligations at international level, analyze these, and fill in the gaps in national laws where these exist. So the model law provides a guide, but each drafter in the specific member state is required to look at the international obligations that that member state has, and to ensure that those obligations contained in those international instruments are actually taken into account. So the UN has also issued a number of legislative guidelines, notes, explanatory notes, and commentaries on human rights instruments, which act as good working tools to the drafters of national legislation for gap analysis in national laws impacting on GBV. And some of the main recommendations of these instruments of the UN have actually been incorporated in the model law. The model law does also, as far as possible, take cognizance of the constitutional requirements of SADC member states, as I indicated earlier. The model law on GBV also seeks to ensure that SADC member states which already have existing criminal laws on GBV need to generally review their laws to a certain conformity with the GBV model law and other international regional requirements and standards. And they may need to pass consequential amendments to GBV laws to ensure consistency and harmony of their national laws. The member states must, when reviewing their current criminal laws on gender-based violence, interrogate gaps in the existing laws, which bring about inconsistencies and disharmony in the legislative space governing GBV. They're also required to ascertain how these may impact on the manner GBV is perceived, prevented, handled, investigated, prosecuted, decided on, and enforced. In this regard, a gap may be manifested as a failure in the coverage, comprehensiveness, inclusivity, rationality, or appropriateness of the legislative framework, and how it impacts on the institutional mandates of the various players in the justice and administrative system. So member states are required to analyze, to take an analysis, a gap analysis kind of, to come up with the areas where they have gaps, and then look to the model law to pick up areas where to pick up principles or even provisions which they could then include in order to close up those gaps. The gaps may include overlaps, conflicts, or inconsistencies within the legislative framework that might result in uncertainty, overlap, conflict, or ambiguity in the law that create challenges or obstacles in managing GBV. The offenses, penalties, and compensation regimes need careful planning and drafting if GBV is to be eliminated or prevented. The model law attempts to do so, but it does not provide for police or law enforcement provisions or powers to enable enforcement or ensure compliance, such as search, seizure, and arrest. These should be provided for adequately in the national laws. Further, the drafters of national legislation may also wish to refer to regional and international guidelines and recommended practices that provide for police and law enforcement duties and responsibilities. For example, the Essential Services Package, which is a guiding tool identifying the essential services to be provided to all women and girls who have experienced GBV, and includes services that should be provided by various stakeholders, including health services, social services, the police, and justice sectors. This ESP also provides guidance for the coordination of these services, provides standards and guidelines for health personnel, police and justice players, social and health services, and for coordination and governance of these services. And interestingly, SADC as a region has also developed similar guidelines. Also, national legislatures in GBV legislation are expected to consider a range of enforcement and compliance provisions that give effect to the GBV model law and effectively prevent or deter GBV from happening. The following factors are key and should be considered when reviewing crafting GBV provisions in the law of national SADC member states. Firstly, the extent to which the root causes of GBV are addressed with a view of mitigating or eradicating them. As you know, if the root causes are not addressed, it will be difficult to eradicate gender-based violence. Secondly, the extent and nature to which GBV is provided for in the criminal and administrative law is also important, and whether gender-based violence offenses provided for contravene fundamental provisions and language of this GBV model law. Language is quite important in matters relating to gender-based violence. So the model law actually contains very clear, specific, and appropriate language, and member states are then required to measure, to benchmark the language in their own legislation against this standard, which is contained in the model law. So whether the offense of GBV is provided for in the law and what the extent of the prohibitions are, that's another issue that member states should be looking out for. And also whether the offenses, penalties, and compensation provisions are adequate and they fit the offense provided. Sometimes in the member states, you'll find that a heinous crime, which is committed, a GBV crime, can have very, very minimal, punishments, and this is a matter of concern. And that's why such a provision, member states are required to also consider whether appropriate punishments have actually been specified to fit the seriousness of the offense. And also they are required to consider whether adequate investigation powers are provided for to enable evidence to be easily gathered, assessed, and used to obtain a conviction for a GBV offense. Other procedural fairness and justice provisions are firmly embedded in the law. Yeah, so sometimes with gender-based violence, the procedures themselves actually may even amount to an injustice if certain things are not straightened out. So it's important for national legislatures or the drafters of national legislation to consider whether procedural fairness and justice are firmly embedded in the national laws, and also whether there is commitment to address impunity and delays in the course of justice. That should also be considered. An efficacious legislative framework on GBV may result in increased GBV cases, lack of access to justice, and continued inequities and inequalities in society. thereby having a negative impact on socio-economic development and continued non-observation, contravention of an individual's fundamental human rights and freedoms. So legislation is quite important, and it needs to be efficacious in order to achieve the intended purpose. The model law on GBV will enable member states to decide on whether to retain the status quo or provide in their existing institutional and legislative frameworks, amend some laws dealing with or impacting on GBV generally and gender equality and equity, or repeal and replace some laws to ensure that they deal comprehensively with GBV and provide access to justice, thus creating an efficient and sustainable criminal justice and administrative system for the fight against GBV. So it's important for member states to actually decide whether they will maintain the current legislative framework or whether they are going to amend in line with the model law by benchmarking against the principles contained in the model law. There are also regulations which are subordinate legislation in the national laws, and they are actually made or promulgated under the national laws. So the model law gives a member states a general guide to the content of all laws on GBV, which can ensure efficacious legislative content for national laws while taking into account regional specificities. It's also imperative that member states must, after enactment of their laws on GBV, which may not be comprehensive as to measures, intervention, administrative support system, procedures, and processes, exercise legislative authority through the making of subsidiary legislation and operationalization of the GBV laws, as these are effective implementation tools for the measures imposed in the GBV model law. So once the legislation is passed, normally you get subordinate legislation like statutory instruments or other regulations, which are promulgated to enable the implementation of the actual statute. So the GBV model law also gives standards for those. The model law further endeavors to deal with both substantive issues and subsidiary matters to guide member states on the extent of the law to be enacted by the national legislature. There are also customary laws and religious norms in the SADC region, which ought to be taken into consideration. And these may impact greatly on women's and children's rights and offend international commitments on gender-based violence, good governance, and or be repugnant to natural or legal justice. Customary laws are recognized as a source of law in most SADC member states where they are not consistent with the Constitution or an act of parliament, and where they are not inconsistent with the Constitution or an act of parliament, or are not repugnant to natural justice. So the constitutions of SADC member states also recognize the freedom of religion. So they must assess their customary laws, religious norms and practices, and attendant institutions. And where these are contrary to the provisions of the Constitution, an act of parliament, or indeed the principles of the model law, or repugnant to natural justice, the member states are expected to amend such customary laws, religious norms, and practices. Let's feedback again. I hope to. Okay, I'll just repeat that. So member states. Is that from me? ICT, are we okay?
Yeah, okay, we just lost you for a moment there.
Okay. SADC member states are also expected to assess their customary laws, religious norms and practices, and attendant institutions. And if these are found to be contrary to the provisions of the Constitution or the law, the acts of parliament, the statutes, or indeed the principles of this model law, or repugnant to national justice, member states are expected to reform or amend such customary laws, religious norms, and practices. Then there are also acts of general application, and member states are required to consider the statutes of general application while adopting or adapting the model law into their national legislative landscape. And these statutes that generally apply to all laws in a country's jurisdiction. For example, the Interpretation and General Provisions Acts, Statutory Portfolio Acts, criminal laws, evidence codes, and financial management laws, because these are general, they will affect different aspects of life. And sometimes they may have an impact on the way the gender-based violence legislation is actually implemented. Domestication and internationally used terms. So SADC member states are required to bear in mind that the Vienna Convention on the Law of Treaties obligates member states to abide by their international commitments. And in that regard, it's important to note that international law consists of its own realm of rules, concepts, principles, and standards, which apply to the conduct of member states and international organizations in their relations with one another, and in some cases with individual groups and transnational companies. These commitments and obligations of states emanate from the rules and standards, so a national drafter must take them into account when drafting GBV laws. So international law is quite an important part of the model law and the provisions that it has influenced. Also, the GBV model law provides guidance for the domestication of various regional and international instruments on GBV in accordance with the commitments of member states under the regional and international instruments. So the model law can actually be used as a very critical tool in domestication of various international obligations or instruments that have been signed and ratified by our national governments, because it brings those out very, very clearly and takes the principles from those international agreements into account. The model law further urges member states to embark on legislative reforms for the purpose of giving effect to their international and regional obligations and commitments, which are generally incorporated as requirements, principles, concepts, standards, measures, interventions, and programs. Should the model law, or at the time that it's adopted by the SADC Parliamentary Forum, domestication of regional and international instruments on GBV will still depend on national legislative or executive action. And this will depend on and evolve according to the requirements and complexities of national constitutional requirements and processes, which may vary among SADC member states. Because some member states follow the monist system, which is self-executing. Once a government signs or ratifies a treaty, it automatically becomes law in the member state. For others, they're dualist, where even despite ratifying or agreeing, entering into an international agreement, the content of that agreement does not become law in the member state, but rather the member state needs to take deliberate measures, specific measures to domesticate, legislative measures to domesticate that legislation. So because of that, the member states will take different routes in terms of domesticating the contents of the model law. So national legislatures may use various methods for incorporating international law into domestic law, such as reflecting the principles of their content or the text in the national law, either directly or in a contextualized manner. It may also be by setting out the text in the national law, either in full or in part, and giving full effect to the regional and international instrument by reference and annexing the instrument as a schedule to the national law. It could also be a combination of those various methods. So the GBV model law uses a number of words and terms defined in regional and international instruments on GBV, and where used in the GBV model law, these are defined as provided in the regional or international instrument with some modification to achieve simplification and ease of understanding, but the meaning would be the same. it's important that the language is adapted to the national legislation. In the national legislation reflects the most up-to-date terminology in the field. Because as you know, I think I mentioned earlier, language is quite important, and certain terminologies are no longer acceptable because of the changes and we're now in the human rights era. So we have to be a bit more careful about the kind of language that we use. So it's important for national legislatures and the drafters who support them to ensure that they reflect the most up-to-date terminology in the field. Appropriate level of competence and procedural fairness. The model law attempts to ensure that decisions are directly taken by the appropriate authority, competent authority, judicial institution, or quasi-judicial body for effective and efficient decision-making. So when member states, SADC member states have their domestic GBV legislation, they need to ensure that actually there are provisions to ensure that the decisions are taken by the appropriate authorities who have competent actually authority to do so. Where discretion is to be exercised, it must be exercised proportionately or comparably in relation to the nature of the decision being made. I mentioned earlier that sometimes you find that a very heinous GBV crime receives a very small punishment. And so the proportionality there needs to be maintained. I think this is what this point is saying, that where people have to exercise, persons have to exercise, or office holders have to exercise discretion, this must be done proportionately or comparably to the decision that is being made. What is it that's being decided? And would this kind of discretion be appropriate in those circumstances? An appropriate authority or competent authority, judicial institution, or quasi-judicial body must act in a manner which affords procedural fairness to victims of GBV, be and appear to be free from bias. So a person who has maybe a victim or an alleged victim of GBV should not feel that from the moment they enter, say, a courtroom, there's bias against them. They should feel that they are going to get a fair trial and to be free from bias. Survivors and victims of GBV must be given a fair opportunity to provide any relevant information before a decision is arrived at. And that decision must be explained in a way the victim of GBV can easily understand, regardless of their background, nationality, or lack of nationality. As I mentioned earlier, there are people who are stateless within our SADC member states. So we can't just stick to nationality. We must say, what about those who don't have nationality? They're still human beings with rights like all of us. So they must also enjoy the same treatment as the rest of us. It's also important in terms of focus. The GBV model law emphasizes that it seems to be more on violence against women and girls. And it also takes a gender-based approach as it applies and is of relevance to violence against men and boys. So the language in the model law does appear to focus more on women and girls, because I think that's where the challenge really lies. But it has a gender-based approach, so it also deals with violence against women and against men and boys. The provisions of the model law should be read broadly to apply to all forms and components of GBV to the extent of the UN and SADC definitions, which I had read out earlier, verbatim, to all victims and perpetrators of GBV, whether gender binary, heterosexual, lesbian, bisexual, homosexual, transgender, and people within same-sex relationships or sex workers. I think the GBV model law is simply trying to be very practical, that these different groups do exist in the society in which we are trying to have this model law passed. However, in general, regardless of orientation and occupation, women and girls are more vulnerable to and experience more sexual violence than males. And that's why there's that focus on women and girls because they are disproportionately affected by GBV. The underlying logic of the subject areas of GBV, of the GBV model law, bear in mind that various categories of users of the model law who will be responsible in the member states for developing, drafting, approving, enacting, and implementing the GBV model law, or who have an interest in monitoring and evaluating the efficaciousness or impact of the model law. So this is quite clear in the model law if you look at it. So underpinning the scope of the model law and national laws, it aptly addresses all GBV issues and challenges, thus providing a comprehensive guide on how to improve, both from a normative, structural, and operational perspective, the response to GBV. Victims and survivors often have little or no access to justice, to report offenses and initiate legal actions, to secure protection, or to ensure that the state investigates crimes and prosecutes the perpetrators. Many times the perpetrators are powerful people, so there is need for a model law to strengthen the legislative response in the region, provide clear guidance for law enforcement mechanisms, access to justice, and facilitate harmonization and consistency of GBV-related laws within and across states. So it's important that these matters are attended to in order to ensure that victims and survivors of GBV actually begin to enjoy access to justice and be able to report offenses and initiate legal action and be protected. An analysis of initiatives reveals that in several cases, countries fail to adequately deal with the problem of contradicting laws and laws that are limited in the type of gender-based violence considered, the result being fragmented and inadequate police and legal developments that fail to address the problem of GBV systematically and inclusively. So a lot of our countries actually have these deficiencies which require to be redressed. The laws and policies have an important role to play in the achievement of gender equality that cannot be disputed. The development of this model law is a critical step in the process of effective legislative reform. So the forum is actually making an effort to initiate and support legislative reform in the member states through this model law. Once this model legislation is adopted, the forum will begin to encourage member states to domesticate and implement the key aspects of this model legislation at national level. The model law will thus assist states to address all relevant areas in GBV legislation where there are gaps or where existing legislation requires reform, I think we've talked about some of the challenges that are existing in the legislative landscape within the region. And hopefully, as members begin to adopt this model law or to adapt it to their specific needs, some of those gaps will actually be dealt with. So the model law follows the spirit and intent of the SADC Declaration on Gender Development, which sets the following 6 specific targets and aims to eliminate gender-based violence. The first one is to enact and enforce legislation prohibiting all forms of gender-based violence, to ensure that the laws on gender-based violence provide for comprehensive testing, treatment, and care of survivors of sexual assault in particular. 3, review and reform SADC member states' criminal laws and procedures applicable to cases of sexual offenses and gender-based violence. 4, enact and adopt scientific legislative provisions to prevent human trafficking and provide holistic service to the victims, including reintegrating them into society. 5, enact legislative provisions and adopt and implement policies and strategies and programs which define and prohibit sexual harassment in all spheres and provide deterrent sanctions to perpetrators of sexual harassment. Adopt, that's number 7, adopt integrated approaches including institutional cross-sector structures with the aim of reducing current levels of gender-based violence by half. So further recognition needs to be made of the Convention on the Elimination of All Forms of Discrimination Against Women, General Recommendation number 35, which was adopted in 2017 in 14th July, and it elaborates on the gender-based nature of gender-based violence, the building on the work of the committee and other international human rights mechanisms, as well as developments at national, regional, and international levels. General Recommendation number 35 is a milestone because it, one, recognizes that the prohibition of gender-based violence has become a norm of international customary law. Two, it expands the understanding of violence to include violations of sexual and reproductive health and rights. Sorry, my apologies. It also stresses the need to change social norms and stereotypes that support violence in the context of a resurgence of the narrative of threatening the concept of gender equality in the name of culture, tradition, and religion. It also clearly defines different levels of liability of the state for acts and omissions committed by its agents or those acting under their authority in the territory of the state or abroad, and for failing to act with due diligence to prevent violence at the hands of private individuals and companies, protect women and girls from it, and ensure access to remedies for survivors. The model further, Recommendation 35 also further unequivocally calls for the repeal of all laws and policies that directly and indirectly excuse, condone, and facilitate violence, and emphasizes the need for approaches that promote and respect women's autonomy and decision-making in all spheres of life. It's important that recommendation number 35 be used as a tool in accelerating and implementing the regional and international obligations to eliminating gender-based violence against women, especially by incorporating the above recommendations into national policies dealing with gender-based violence. In brief, the creation of a robust, inclusive, and uniform legislative framework relating to GBV is a key path to addressing GBV in SADC member states. The GBV model law gives guidance to national legislatures on how to give effect to national policies, enact national and hold national executives accountable in implementing strategic plans that aim at addressing GBV. The GBV model law endeavors to address GBV using a human rights-based approach, underpinning principles which are visible in the objectives, rationale, and principles of the GBV model law. I think I alluded earlier to the issue of COVID-19 and the emerging trends that have come in the advent of this pandemic. So briefly, a quick look, the COVID-19 pandemic has seen an increase in cases of GBV in the SADC member states. There has been generally a global increase actually in the GBV reported cases as a consequence of GBV. And because of this, there's a continued outcry from survivors and victims that society, organizations, the international community stakeholders, and they are looking for effective solutions to address GBV, including putting in place more stringent and innovative measures to ensure that the COVID-19 pandemic does not act as a stimulus for increasing instances of GBV, or at least that the situation can be arrested at the moment. The GBV model law therefore attempts to provide innovative solutions and measures in investigating, assessing, prosecuting, deciding on, implementing, and managing GBV and attendant cases. In terms of form, the model law is structured in the style and form of approved or adopted SADC model law, of the adopted SADC model law on child marriage and protection of children already in marriage, which are model laws that have been adopted by the SADC Parliamentary Forum. And they set a good precedent that has been established by the forum in terms of structure and form. This will assist SADC-PF to build up on their compendium of model laws that are authoritative. The GBV model law, therefore, does not conform to any individual member state's form and structure. It doesn't have a memorandum, a long title. It does not have a memorandum, a long title or short title, but it has a preamble which outlines the SADC member states' regional and international commitments on human rights and gender-based violence as spelled out in those instruments. I would, at this point, like to quickly just go to the key provisions. The key provisions of the model law. And these are contained from part 2 to part 9, actually part 9. And I'll quickly just highlight what each part contains so that the participants can then have a discussion maybe of the issues that have come up. So in part 2 contains preliminary provisions. And these are general issues relating to the substance of the model law. They basically consist of sections on domestication, objectives, scope, and application and interpretation. So these are contained in part 2 of the model law. In part 3, the human rights approach is actually highlighted in this part. And this part seeks to ensure domestication of international human rights instruments. And also this part restates some of the rights, and I think I talked about this earlier. Some rights are restated and policy guidance is also offered towards development of policies and strategies to help eliminate gender-based violence. This part also takes into account international human rights instruments, plans, and strategies, and it provides for prohibition and discrimination. And then part 4 deals with access to justice. This part deals with various aspects of access to justice and procedural protections, which I've already explained. Part 5 deals with effectiveness of the response to GBV in the SADC member states, and it sets out provisions that to stimulate a quick and effective response to GBV in whatever setting it takes place, that is in the private sector or in the public domain. It includes simplified procedures for response and referral. Part 6 of the model law deals with prohibitions, offenses, and sentencing. It emphasizes the need to put in place legislative measures to prohibit, provide adequate offenses on GBV. I think I mentioned this, that the offense provided and the punishment needs to be proportionate to the injury or the offense that's been committed. So it provides for that, measures to prohibit. It also provides for offenses, supportive measures, and restraints while ensuring that sentencing policies are well streamlined to ensure deterrence. Some notable provisions are prohibition of gender-based violence, collusion in gender-based violence offenses. It also provides for factors to be taken into consideration in sentencing. So it helps with sentencing policy as well. Part 7 deals with protection, prevention, and intervention measures. The GBV model law incorporates protection, prevention, and intervention measures as espoused in international, regional, and continental instruments and recommended strategies by various protagonists in order to enable member states to tackle GBV in an efficacious manner. I think we did discuss the international, regional, and continental instruments, and I cited some of them that are actually mentioned in the model law area. Part 8 deals with capacity building and awareness. And the model law in this part endeavors to provide for training of relevant public officials, judges, police officers, social workers, immigration officers, for effective GBV detection, prevention, investigation, prosecution, protection, and awareness. So all these actors in the process of handling GBV cases actually require awareness, and capacity building in terms of how they can handle cases of GBV. And Part 9 provides for general issues. It deals with information and data protection, research and development, financial resources and budgeting, enforcement, compliance, and regulatory issues, monitoring and evaluation, as well as reporting. At this stage, I think I would like to leave it there so that we can have more time for discussion, especially looking at the time. If there are any questions or comments, perhaps those can be taken at this stage. Thank you.
Madam Sonda, for a very comprehensive presentation, both in terms of the context, the scope and content of the GBV model law. At this juncture, I wish to open the floor for any discussions, questions, comments. I already see Alfonso Maka and His Royal Highness King Mufumu Difima Dino. So I will have those two. I'll start with Maka, then I will have King Dino.
Oui. Bonjour à tous et merci.
Hello, everyone, and thank you, Maka Alphonse, Chair of the Reconciliation Board in Madagascar. And I would like to be very, very brief. Firstly, when it comes to Madagascar's constitution, I would like to emphasize that it is in line with the Malagasy constitution. The model law is in line. And then the speaker has an echo on his side. Could he? Madagascar has already ratified the International Convention on the Rights of Women and especially on the rights of children. So I would like to comment a little bit because we have a certain tendency to mention or to think that gender-based violence is usually based on violence against women, because there are men that are also victims of violence. Therefore, the model law is rightly neutral when it comes to the gender-based violence, meaning women, girls, boys, and men. It's good. And I would like to also mention the specificity of Madagascar, because there is a law, a legislation in Madagascar that is found nowhere else. It is the law on I would like to be more precise. When there is disagreement between couples, Malagasy women have the right to leave and go to their parents or their in-laws. But the men don't benefit from this right. It is a unique setting and a unique legislation in Madagascar in favor of women. If I have to add, Malagasy women are not considered as sub-citizens. No, because since even before the Republic, even during the kingdom era, women ruled. There were a lot of tribes who had queens at their helms in Madagascar, and still we have queens and princesses. Within the CFM members, we have a queen that comes from the region of the northwest of Madagascar. Therefore, we don't have this paradigm of inequalities between men and women, but there are a few regions, especially within their traditions, practice polygamy, for example. Uh, Now I have a question. Is polygamy considered violence against women? Uh, that I would like to have a little bit of clarity on. And the other question I would like to ask is regarding the couple. When there is a denial of or a refusal of sexual relations or sexual intercourse, is it considered a violence, a gender-based violence? And when it comes to the conception and the law design, we have to consider religion and tradition in order to avoid culture shock. So when we are integrating this law into national framework, we have to be careful and avoid this culture shock, because there will be a certain passive resistance from the citizen and from the population. And in order to avoid that, we have to take in consideration local traditions and customs. That would be wise, I think. Thank you.
Thank you very much, Honorable Maka. I now invite King Dino.
Oui, bonjour et merci. Je ne sais pas si vous m'entendez là.
Thank you. I don't know. Can you hear me?
Yes, I can hear you very clearly, Honorable.
Okay, merci.
Thank you very much. His Highness, I am at the helm of the Council of Traditions and Religion in DRC, Vice President of Traditional Affairs in Africa, an instrument that was implemented by the African Union and that is working with UNICEF and UNFPA. So I'm firstly very, very grateful for the invitation at this consultation, because here I would like to emphasize that the implementation of Kutla Konata was done on the basis of the invitation of UN women who had real issues with gender-based violence, female genital mutilations, and child marriage. And yes, we acknowledge that there were concerns that you are trying to bring solutions to these problems, but what are the channels that we are using? Because the concerns are not necessarily the most important. What are the platforms where we exchange and bring suggestions for solutions? First, I would like to congratulate Ms. Musanda for her presentation, and I sent her a message in order to get the presentation by mail. I really would like to read it in details because she really summed up a lot of problems related to women and young girls and their independence. And this could be a book that we could read and comment on. But I would like to go in the same spirit as my predecessor that said in his concern that violence is gender neutral. It's a culture. It's no longer a woman, a man, or a children problem. It is the results of a problem at community level. If we have to talk to Africa and if we have to go back to the kingdom era, we will remember that we had queens that were rulers, that were symbolic rulers, that were constitutional rulers. And when we want to talk about this type of cases, the academic, the the researcher, and the people that are in the domain must think, are we thinking about the post-colonial era framework, or are we talking about Africa that we want to rehabilitate? First, we say, yes, there are violences. Yes, we have to solve it. But now we are talking about traditional leaders and religious leaders. But we forget that religious leaders are in different traditional setups. The African setups of tradition and customs is also different. We are talking about custom and traditions and religious laws, and then we talk about international law. But we condition the existence of our law, African laws, tradition laws, and we attach them to the compatibility to international law that are none other than foreign laws. It's as if us as independent entities, we only recognize ourselves as humans through the lens of international law or foreign law. We are not considering the basis. So there are violences, as Mr. Mack has said. Is polygamy a form of violence? In Muslim religion, it has been integrated, it has been accepted. But in a Catholic religion, it has not been accepted per se, but it is not frowned upon to have a mistress and to have a concubine. And that comes from the Greco-Roman culture. And polygamy is mostly accepted in Arab settings. So we have to think there is a real work to do when the customary, traditional, and religious leaders coming from all these different settings are thinking about violences and are realizing that something is missing. What is missing is that we have thrived, we have fought for independence, and now we are trying to find solution through conferences, through debates, through discussions, but we will not have solutions. Let's take an example. The safety nets against the mosquitoes against malaria. We have a campaign and we distribute them, but we have not gone to the swamps, the garbage cans, and the sanitary environment that actually foster the existence of mosquitoes. Distributing safety nets will not solve the problem. That's the same thing here. First thing, as we are looking for solutions, we need to find solutions to eradicate violence. When we talk about child marriage, there is no child marriage. There is child pregnancy, early pregnancy. It's not because we give the child to the family of the young boy that is responsible for the pregnancy. We cannot qualify this as a marriage. What we should do is define our cultures as positively as we can, because the West is degrading or denigrating our own culture. So we have to listen to our traditional authorities. We have to listen to our traditional laws as a basis. Their international law should be compatible to our law, not the other way around. How are we going to be an independent and strong Africa if we don't do that? In which law, in which legislation, in which text do I have the authority to establish and legiferate and legislate on laws? Because now we only have symbolic roles, while our tradition and our customs are the basis of our existence. When I see this work, I believe that we are going to the second part, which is finding solutions that are definitive and real for the communities, instead of just shifting, moving objects. I don't really know if it's going to be possible if we take this approach. We always accompany and support, but we would like that each and every country and each and every state value their African culture. Because SADC is just sitting on customary laws, traditional laws, and demand that we accommodate or that we comply to international law. I would like for us to be on a more equal footing. For those who fight against this plague and for those who are the traditional leaders, they should be on an equal footing. Because right now, it's not an equal footing. And now we are not really working together. It's like we are fighting each other. We should be on an equal footing, and we should be considering solution and find a middle ground that will satisfy everyone. This is what I wanted to tell you, and so far I wish us good deliberation, and I wish the ancestor smile upon our discussions today. Thank you.
we are not certain as to whether there are some mics off of any speakers, but we haven't not been able to capture anything to interpret into the Portuguese channel.
In the Portuguese interpreter, you're struggling with something?
Yes, sir. I don't know if anyone is taking the floor because we are not capturing anything. I was just bringing the meeting's attention to that. There was absolute silence, and I was just wondering if someone was speaking with the mic off. Thank you, sir. That's all.
Okay, noted.
Okay,
thank you very much, King. We now give the floor to Honorable Jean Marcel Meandrisoa from Madagascar. You have the floor.
Merci beaucoup et bonjour.
Thank you very much.
Good afternoon.
Hello.
Meandrisoa
Jean-Marcel.
I'm part of the council in Madagascar.
Vice Chair of the Commission on Rebuilding the Nation and Republic.
And a professor.
Professor at the
one institute in Madagascar, as well as
I'm a traditional leader of the Kanush Kingdom
of one of the tribes.
And I would like to thank you for this presentation, which is a very rich presentation
that we're having.
But for my intervention not to be too
really
lengthy, I must mention that it is not
impossible to think
that our culture and customs should
the international culture
overpowered by the international norms and
culture.
standards. I won't repeat what my predecessors said, but I will
but I'm not going to enter into details, but I'm just going to add something on the violence, which is based on gender, and I think it has got many things to do with
Why
poverty.
is there poverty?
Why is poverty? I'm going to speak about it. The developed world today
countries and
is
developed countries,
having an excess
they are in overproduction and overconsumption,
while our countries are looking for food. So what do they do? Then the girls and the women to feed themselves, then they go to men. So this is actually to say that we must look for ways to eradicate poverty so that we can fight gender-based violence. So if we speak about women, I want to encourage every member state to think and then to put into practice a mechanism which is going to help the ladies and girls in order for them to develop themselves while using, more importantly, existing capitals such as the lands, the food, as well as the wild stock, the farming activities. This is going to push now people to use this means to eradicate violence, because poverty is the one that is there to is actually driving the gender-based violence, because the women have to go and look somewhere to get a favorable condition. From the well governance from the madam that I just spoken now, Madam Musonda, the human rights, environmental conditions, and all these conditions, they must be in conformity of the realities of the countries, so that we must give the emancipation of each and everyone, women and the men included, so that the international laws as well as the national laws can coincide. This we have to look for finances, and today there are some institutions that are there, but it's not easy for these institutions to assist so that we can emancipate, we can eradicate poverty. While when we speak about Madagascar and Africa, the lines is actually rich. So what I'm saying is that if we really need to help and eradicate gender-based violence, we must really work hard to eradicate poverty so that we can eliminate the dependency of women, as well as internal migration of people between the regions, and also in respecting the culture, the national culture, which should actually be adapted to their life, to their daily life. This is briefly, my good friend, a few remarks which I want to speak out, because this subject that we're talking about is very important for us, for the nations, and for Africa, as well as the member state of SADC. So we really need to think on how to put in place a mechanism to eradicate poverty, so that the mother, who is the woman, can really inculcate in their children that the education and the coordination of means that are going to allow them to emancipate themselves. I would like to thank you very much, Madam Chair.
Thank you very much, Honorable Marcel, for that intervention. The issue of equality of laws, the issue of access to means of production, and eradication of poverty as a means to stemming out GBV. I now have the pleasure of inviting Nyasha Mandosi to make the intervention, and Nyasha, you'll be the last one in this round. Then we'll allow the presenter to respond before we open the floor again. Nyasha, over to you.
And I also want to thank the Madam Presenter for a very comprehensive presentation. As a young woman, I just want to understand that, is there any provision put in place at national levels for traditional leaders as custodians of, is there any capacitation that has been put in place for traditional leaders as custodians of the culture on the SADC model law, as some of the cases of gender-based violence are being reported directly to their traditional courts? So I really feel that we need to be speaking one language together with our traditional leaders regarding this model, SADC model law, so that we can actually help our adolescent girls and young women at least.
Thank you very much for the question. At this juncture, allow me to invite Madam Sonda to make to respond. Maybe before she does, just to assure participants that copies of the presentations and the model law would have either been sent in advance, but if they have not been sent, please drop your emails in the chat box or send an email to gbv@sadcpf.org, and we will be able to send you copies of the both the presentation and the draft model law. I wish to inform the King that we have since sent the presentation to his email. He should be able to have received it now. Over to you, Madam Sond.
Thank you, Mr. Moderator. A lot has been said, a lot of value, and my first comment would be that some of the comments have been taken note of by the rapporteurs, and because this is a process of consultation, so it's important to hear what stakeholders, important stakeholders like traditional leaders and leaders have to say. And
just a moment, Madam Sonda. ICT, could we mute mics that are not having the floor, please? Thank you very much. Please proceed.
Yes, thank you, Mr. Moderator. I was just saying that there's been a lot of commentary, which is very valuable and which our rapporteurs are taking note of. And because this is a process of consultation, so it's to improve the efficaciousness of the law. So some of those areas. You can hear noise again. I hope we're okay.
Yes, there's a mic that is on. Okay, I see it's off now. Please proceed.
Okay, so the valuable contributions that have been made by the speakers generally will be taken into consideration, because this is not yet a finalized document. This is part of the consultative process. But to comment perhaps specifically on some of what I got to be questions, there was a clear question on whether polygamy is considered to be GBV. In my opinion, GBV it's also contextual. So you need to look at the custom, and is there something happening beyond just the marriage? Is there something that is related to that is causing hardship or a violation of someone's rights? That's what would constitute the violence. I do not see marriage itself, the marriage itself, polygamous marriage, as gender-based violence.
Madam Sonda?
Yes, please.
Just a moment. There's a request for you to stop sharing your presentation so that we can have the pleasure of seeing your face as you present. That's much better. Please proceed.
Okay. So, yes, I was talking about the question on whether polygamy is considered to be gender-based violence, and I will request Secretary General probably to comment on this. But my view on this is that it depends on the context in which it's happening. Is this a polygamous marriage to a very young child? Probably. Is there some physical violence involved, some emotional violence, economic violence? All those things can arise in those settings, and that's what needs to be considered. The fact of the marriage itself may not necessarily be, like I think it was indicated in the Islamic culture, it is seen as it's normal. It's part of the culture that is in those societies. So I think other factors have to be taken into account in order to determine whether a violation has actually happened of someone's rights on account of their gender or their sex. Similarly, refusal of sexual intercourse, I think it's contextual, because if you look at a situation where, even the same example I gave of a child being married, or I think the king even put it better, that there's no marriage there, it's just a child being pregnant, made pregnant. There, you would say there's a violation, even if this person who is with a child or who is purporting to be married to a child may say we are married. There's a violation of someone's rights because this is a child. So in those circumstances, if the child does refuse to have sexual intercourse in those circumstances, you would not say they are violating someone's rights. So it's always contextual. I think it's important to look at the context in which these, the settings in which these occurrences take place, and that's what would inform the decision as to whether this is a violation or not. I think there was a comment on the need to be careful and avoid the culture shock as we proceed in terms of coming up with such legislation, or even implementing, domesticating and implementing it. I think that's a very valid concern. It's always important to be contextual, take account of the context in which this law is going to be placed, and make sure that you carry everyone along. And I think part of the process is exactly what we are doing today. The idea is to make sure that everybody, the custodians of culture also, are involved in this process. So that to avoid that culture shock, the custodians of our culture should have a say on what goes into the model law, and also to have ownership of it, to say, okay, yes, this law has, but we took part and we agreed to or acquiesced to some of the contents therein. So I find this process today quite important in terms of ensuring that we attempt to deal with. It's an attempt to deal with this culture shock, because it would be more shocking if the traditional leadership or the religious leadership had completely no idea and the model law just comes out there without necessary consultation. So I think that today's meeting actually goes a long way, or at least goes some way, in trying to avoid or address the issue of culture shocks. I think the issue of the copy of the presentation has been addressed by the moderator. And also there was a comment on the fact that there appears to be a bias towards women in terms of but I did indicate that the model law actually takes a gender-based approach. So it does cover everyone. Of course, there are many provisions which deal with women and children, because we recognize that they are disproportionately affected by the challenge of gender-based violence. And it's true that there have been women rulers in the SADC region, and this also will be taken into account. So yeah, I think that the model law does take a gender-based approach, which is recognizing the challenges where they lie and dealing with them in that manner. And then there was a concern on finding solutions to eradicate child marriage. This is another concern which also contributes to actually gender-based violence. And at the SADC level, at regional level, there has been an attempt. A model law was actually promulgated a few years ago on child marriage. And again, there was leadership from among traditional leaders. For example, as far as I can remember, there was quite good leadership on that particular model law. It assisted quite a lot. The acceptance levels and participation was very, very high from the traditional leadership. So the SADC Parliamentary Forum continues to make model laws which should assist to entrench the principles that we would want to see, the ideals that the region would like to have and live by. So that's something that the forum is doing. Then there was some concern regarding the fact that international law appears to be taking over from cultural values. I think there were two speakers who talked about this. I think the statement, is it not possible to think that our culture should be overpowered? It's not possible to think that our culture should be overpowered by the international agenda. Yes, I think that all nations have their own, domestic context, and even societies have domestic context, which includes the custom, a very big part of it, the custom of the community, and also the religious. If we look at today's meeting in particular, those are very, very important, and they are taken into consideration. At the same time, the state also has obligations. Remember, these nations, the SADC member states, have actually signed up to say these are our ideals as a country. So they have agreed. So the SADC model law on GBV is not introducing anything that these member states have actually not agreed to. It's not like they're bringing a culture from some other place, which the member states have no idea about, and bring it into the SADC model law on GBV. They are actually drawing. I think I read out a list actually of international conventions which SADC member states have already agreed to. So these are already ideals which are agreed to, so the assumption is that these are accepted, and some of these are quite old. They're not new convention treaties. So they've been agreed to by the SADC member states, and these are the ones that the model law is drawing from, the things that are already agreed. They're on the table, and actually most of these member states are already even reporting how much progress they're making towards achieving those. So this is just like a push towards achieving some of those goals, particularly those relating or having an impact on the issue of gender-based violence. Then there was a concern with regard to the levels of poverty, and I think that it was a very valid concern, that violence has a lot to do with poverty, and we would do well to make efforts to eliminate poverty, and that would help us to eliminate or at least reduce the levels of gender-based violence. That is very true, and it's one of the things that are contained in the model is to try and assist. I think we talked about protection and support to victims and survivors of gender-based violence. But perhaps that another area that needs to be is prevention. I think there's also issues of prevention. And in that area, perhaps that's an area where there could be some expansion relating to assisting with economic activities prior to someone becoming a victim or a survivor of gender-based violence. But indeed, it is a very, very valid concern. And perhaps it's a matter that can be taken note of for further consideration to be taken forward as the consultative process comes to a close and the consolidation of the model law is being done. And then there was a question, I think the last one was on, is there any capacitation for traditional leaders on GBV at national level to help them handle such cases because they come before them? And one of the provisions, actually, I think in Part 8 of the model law actually talks about capacity building and awareness, and it talks about relevant public officials. It does not necessarily talk about traditional leaders, but it talks about judges, police officers, social workers, immigration officers, and encourages member states to ensure that there is capacity building and awareness among these officials, because these people handle the issues of GBV. Therefore, in that case, I would agree that it's important for us as we going forward with the model law to actually take note that traditional leaders and probably religious leaders also who have to, I'm sure many times have to handle cases of gender-based violence must be included in the capacity building and awareness that is being proposed in Part 8 of the model law. I think I'll end there. Maybe SG has some additional comments to make or responses.
SG, do you wish to make any comments?
Thank you very much, Mr. Moderator. Just to appreciate the interventions that have been made and to appreciate the responses that have also been fielded in this regard. Allow me, I'll just take from the broad thematic issues that have been highlighted as concerns, and mine will just be to assure our august traditional leaders and religious leaders of key issues that underpin the value of the model law. And there was a question, let me start somewhere. There was an issue of whether culture and international law conflict. I like the response that Madam Musonda gave, but I'd also like you to I'd also like to admit that yes, international law and culture do conflict. And I'll be able to say a few things about this, but allow me to also say that it is reconcilable, because international law is based on equality and equal protection of the law, and that all human beings are born equal. But culture in many of our societies tends to privilege men and treat them as more superior than women. And this is the conflict that I'd like for us to just think about and reflect on. We know that far afield in many of our countries, let me just say, I heard one of the speakers speak to the issue of, the Muslim culture, let me just say Islamic countries, women were not allowed at some point to vote. Some are still not allowed to drive. We're not allowed to drive until these are the issues that bring me to issues where culture has never been constant. And we see progress in most of these countries where these changes are actually taking place. So let us find comfort in the fact that the link to culture and the threat of international law to our sovereign nations is a characteristics that is actually something that we can reconcile. And maybe let me bring a principle which is a structural issue in all the issues that we struggle with around socioeconomic development or the issue of gender-based violence. History has taught us over time that in most societies, we struggle with the issue, or let me say a system of patriarchy. We can talk about gender-based violence, but if we don't integrate the issue of patriarchy as a system that exalts male power and domination as one of the key factors that explain gender-based violence, then we may not be able to get to the capacity development that we endeavor. We are aware that in most cases, when cases get attended to on GBV, you find that at the bottom of everything else, the sad history of humanity is based on power relations. And I believe that this is something that we should look at as we deal with issues of gender-based violence. History also teaches us that there was a time where children were to be seen and not heard, when women were rarely remembered as individuals, even when they did great things. But this has since changed because of the underlying factors where all of us are looking at issues of equality as what binds us as nations, that binds us as human beings. And therefore, let me just maybe end by drawing a relationship or a nexus between the relationship between law and culture. If we can look at law within the cultural realm as something that binds us together, that assists us in terms of how we can relate to each other, then I believe that we'll have as many champions in the society, including yourselves as leaders of culture and religion. And allow me to also indicate that this model law, in our view, is not meant to undermine culture in any way. We understand that culture is not simply a set of customs that we can choose to put on today, take off tomorrow, discard, shred, and do like we do with clothing and paper. We appreciate that culture is woven into the fabric of our being. And therefore, any law, any intervention, we have been taught that cannot disregard the power of culture, religion, among others. So we cannot disentangle the implementation of the model law from culture. We cannot disregard this because it is deeply embedded in how we're going to carve our laws, in how these laws are going to be received, and ultimately how we're going to have you be responsive or help us move on in mitigating issues around GBV. I would like to appeal to this august house that the issue of culture and imposition of international law should not distort the good intentions of the GBV model law. Rather, it should help us in terms of issues of power, domination, and the basis of the fabric of society, where we find that some of these things are not what culture actually would like to associate with, nor religion. So culture will ultimately, at the end of it all, be a driving force behind the legal pluralism. So assuming that we can disregard culture is out of the question. I would like to appeal to this August Assembly in this regard, and also look at, we will task ourselves as a SADC Parliamentary Forum to continually link with civil society organizations. We have the AU Goodwill Ambassador, who has worked with us very closely when we were developing and adopting the model law on child marriages. And we had chiefs that came to the fore to celebrate with us when this was adopted. And this is the appeal and the context within which we bring it to the table, and we take you seriously. And I'd like to take the comments that Mrs. Musonda has made as mine, because this is the spirit within which the SADC Parliamentary Forum interacts with the citizens of SADC. As you know, parliaments represents everybody in their diversity without exception or discrimination. And let me end by saying the issue of women and men with regards to GBV is simply based on facts. The evidence points that the majority of people who are greatly impacted by GBV appear to be women, although we are also registering a huge number of men and boys who are also impacted. And this is part of what we do not want humanity to be remembered for. I thank you, Chairperson, and I believe that with just those few global comments on the subject matter, this will bind us. The ideology of patriarchy, like I said, lies at the heart of unequal relationships that we find our societies in today. And this is not what we would like to continue in our discourse. This is not what culture teaches us. And therefore, no vulnerable person in the community should be left powerless to a point where they cannot hang their hopes on the protection of our gatekeepers such as yourself, or even hang their hopes on the law for protection. I thank you, Director of Ceremonies.
Thank you very much, Madam Secretary General, for those comments. Our distinguished participants, I want to open for another round of comments and questions. I see Honorable Theogene. Please, you feel free to take the floor. You are muted. Please unmute. Honorable Theogene, you are muted.
C'est bon? C'est bon?
Yes, yes, I can hear you now.
Voilà, merci.
Thank you, Rationale Theogene. I am Executive Secretary at the CFM, and I come from the legal domain. His mic seems to have turned off, or is it only me?
Probably it's you. I see that it is on, but can you hear him now?
No, his mic is on, but I can't hear him.
ICT, could we deal with the issue of interpretation there? The interpreter can't hear the honorable member.
Now, the interpreter is has a mother.
Is it resolved?
Still not. I can't still hear him. Still can't hear him.
Honorable Theogene, if you can hear me, the interpreter is unable to hear you. Can you hear him now?
No, still not.
Uh-oh.
While I'm hearing you fine.
ICT, are you able to assist? We're struggling to hear you, sir. Honorable Theogene. Are you able to hear me?
I could see he said yes, but I couldn't hear him. Yeah.
Maybe you could write in the chat, interpreter, to indicate that
All right,
we are unable.
We'll do right now.
Sure. It's possibly to do with the gadget, because at the beginning there was feedback which showed that there were two gadgets in the room.
Yes, it's on his. Because earlier we were able to hear him, but now it's we cannot hear anything. Can you try something? Log him out.
Yeah. Hello. Yes, Honorable Theogene. Yes. Can you hear him now, interpreter?
Yes, I can.
Yes, you can proceed. We were not able to hear you, so please indulge us and put your question and comments from the beginning again.
Thank you. I will not talk about the content questions and the background interventions that were given, but I am a legal practitioner. I have a PhD in public law with a specialty geared towards international law, and I have taken part in the redaction of a lot of laws, a lot of bills here in Madagascar, especially constitutional law. And when it comes to the concern and the question that is really interesting us today, when it pertains to the relation and the cooperation between SADC and its member states, there is this SADC model law against gender-based violence that really aims at eradicating and eliminating gender-based violence. So I would like to take the legal approach for my side. One of the fundamental issue with international law, which is a decision around these type of law, is dependent on an internal law, a domestic law of member states. Because when I was listening to the SADC experts, some points in her presentation really made me pay attention. Firstly, there is the one that comes to sentencing. When it comes to sentencing, I really paid attention, and there is another item mentioning the mainstreaming and the integration of the SADC model law in national member states legal framework. And I would like to mention this concern. When it comes to the sentencing regime, if those are if it is civil or criminal sentencing. My question is this: at SADC level, how these SADC model law has treated or mentioned the competence of the judges at national level, because sentencing is really about the sovereignty of states. It's really about the sovereignty of the member states. And another legal problem or issue is the integration and the mainstreaming of the SADC model law in the national law. Because when I was listening to the expert earlier, I think I heard that member states' constitution should go towards adapting the model law, but I haven't seen how. I haven't heard how this adaptation would happen, because each and every member state has its own legal system. So there are some states there are some systems that have the dualist systems or monolithic systems. So when it comes to integration and mainstreaming of the SADC model law in national text, those are different approaches, and it could even lead to potential problems. So in Madagascar, we have a monoist system. An international law is adopted by the relevant national authorities, and it must first have the approval of the parliament before entering in force in the national legal system. So my question is this one: is this SADC model law does it have an international nature when it comes to Madagascar constitution and legal system? If this SADC model law doesn't have the level of an international treaty or convention, I don't see how it can be integrated or mainstream. So my suggestion is that this model law, if it has to be integrated, this model law must become an international treaty or agreement ratified by relevant authorities that will then receive the approval of parliament. And if that procedure is respected and followed, then it could be integrated in the legal system, and it will even have a superior importance, and even more, an even higher degree of precedence over other laws. But I have to mention something, because matrimonial laws in Madagascar are quite specific. We have mentioned it earlier by the chairman of the CFM. So it means that this SADC model law will be the object of much reservations. And when it comes to the reservations, to conclude, I have just two suggestions, because earlier, when I was watching the expert's presentation, I'm deciphering an intention of rendering this SADC model law text that has to be redacted in a civilist manner, meaning in a very, very detailed fashion. But when we take this approach, it will be very difficult to adapt and to integrate this model law in domestic settings, because each and every country has their own specificity, their own context when it comes to social and legal systems. So the redaction of this model law should be a constitutional style. That way, its integration in national legal systems will be a little bit easier. And last suggestions, there should be an evaluation system. We need to prepare well in advance a system to evaluate the SADC model law in order to evaluate and know which countries have laws that are the closest to this SADC model law. So we wouldn't have to lead these countries to re-examine, to re-evaluate their own laws. If we have an evaluation system, if we have an assessment framework, we can know which countries are geared in the legal systems toward this SADC model law. This is my intervention, and I'm sorry if my intervention is a little bit too technical and fidgety, but this is coming from my professional background. Thank you very much.
Thank you very much, Honorable Theogene, for that question and comment regarding the process of adopting and adapting the model law vis-a-vis the different legal systems in the member states. I'm sure the presenter has taken note and will be able to give sufficient response to the question. I see another hand from La Princess Zo. I'll call her La Princess Zo. You have the floor.
I need to recommend it. No. Oh, oh. Honorable
Honorable members of the SADC Parliamentary Forum, honorable traditional and religious leaders and parliamentaries, Madam Secretary General of the SADC Parliamentary Forum, I am Her Highness Princess Zwendrenini Ella Covello, Chair of the Royal Communities and Traditional Communities of Federation of Madagascar, representing the great royal families of the Greater South, and it is my great privilege to take part in this consultation with traditional and religious leaders on the SADC model law against gender-based violence. Gender-based violence is the topic of many discussions at international and national levels and traditional and religious leaders around Africa. The National Congress of September in 2012 in Madagascar has given the declaration of the engagement of the royal families and the National Coalition of traditional leaders, the conferences of queens and traditional leader women with the resolution of Morocco 2018 on a union of traditional communities in Africa. Those engagements are geared towards the rights of traditional communities around Africa. As an authority for the traditional and religious community in Madagascar, on the consultation against gender-based violence, regarding the human rights, the values, and the principles of humanity, recognize and acknowledge the respect of traditional laws and customary laws, especially in Madagascar, due to the consideration of different social, economic, and cultural contexts is under the attack of the COVID-19 pandemic. We have therefore adopted a collaborative framework and respecting different cultures, customs, and traditions in Africa. We have different propositions and suggestions to amend this SADC model law. And we have a few amendments in mind. In the third part, 35, the rights of victims relative to legal procedures and legal proceedings. 2, the following provision on cases related to gender-based violence cases. 2, no laws or rights or customary practice should be used to justify acts of violences against women. We should consider case by case the different member states when it comes to the application of these specific articles. We also have in mind the part 7, awareness and communication with the public. We have the campaigns of communications that are led by relevant national authorities, local authorities, and regional authorities. We suggest the engagement of traditional and religious leaders in the awareness campaigns to audiences, because we are important stakeholders when it comes to positive behavior change in order to optimize the impact at community level. Part 8. At the third part, we suggest the engagement of traditional and religious leaders
Madame, Monsieur, à toute bonne tentative.
Ladies and gentlemen, we want to work towards sustainable development for populations of Africa, and we want to work hand in hand with you to the betterment of the citizen of the region. Thank you.
Thank you very much, Princess, for the comprehensive submission. May I request that, if possible, the submission be emailed to the email that I shared earlier on, which is gbv@sadacpf.org, so that the drafter has full sight of it and is informed accordingly. At this juncture, I recognize the presence of Senator Chief Fortune Charumpira, the president of the Chiefs Council in Zimbabwe and the vice president of the Pan-African Parliament, the last I knew. Over to you, Chief Fortune Charumpira. You are muted, Vacharumbira.
Thank you, Moderator Dr. Kurasha, Secretary General of the SADC Parliamentary Forum, honorable members of Parliament participating. And in fact, I should have started with our traditional leaders more than anything else, because lack of recognition of our own values is also a cause of gender-based violence. But we have relegated our values to a point where people have become violent. So I'll repeat and say traditional leaders, our Secretary General, with our MPs, then Secretary General. That should be the order. And other participants, I should apologize that I did not follow proceedings from the beginning because I had other engagements, but I was keen that I can't lose this very important discussion. And I want to start by saying congratulations and thank you very much to the SADC Parliamentary Forum. This is very, very important. I'm not aware of such engagements by other institutions that are so wide and so inclusive, so participatory, in discussing such important issues, not only within our own national environments, but also the region and the continent of Africa and outside the continent. My comments will be as follows. First is to congratulate you. The first is, see, gender-based violence has been very topical, especially in the last 15, 20 years, at least for my own understanding. And a lot of initiatives have been undertaken. I don't think there is a country today that has not passed a law on gender-based violence. A lot of instruments international, I remember in our own parliament, we've even ratified some instruments. So, Mr. Moderator, I think the first issue which I want to interrogate is, what is the real problem? Is it about law, religion, or culture, for example? As we draft the model law, we should continue interrogating these issues. Is it the law? Maybe, yes, as the presenters have said, there are a lot of gaps in the law, and they are right. But if we close those gaps, assuming we do, are we sure that the incidences of domestic gender-based violence will simultaneously go down or decline, or some of the vestiges and the sediments may still remain? And the issue of religion, I think at some point we need to be open and say, to what extent does the religion contribute to gender-based violence? I think it's a research that has not been conclusive so far. And the issue of culture, to what extent does culture exacerbate the problem of GBV? I am coming in as a parliamentarian. I'm not actually a vice president, I'm acting president of PAP, and also a parliamentarian in Zimbabwe, a leader of the whole chiefs in our country, Zimbabwe. So I've been very much ingratiated in these issues, both at national, regional, international levels, very much ingratiated in these issues. And when I say culture, for example, you then wonder, what about culture? And who is this person? Who are these people? Where are they? I think let's do research which is more directed and specific, and say the people in the one part of this country are doing this. And we all work together with our parliamentarians, government, and say, can we descend on those communities whose cultures are promoting or exacerbating gender-based violence? I want to say, Mr. Moderator, that with regard to culture, we totally in Zimbabwe condemn any person, male, mostly male, of course, some women, who are perpetrators of gender-based violence. We in Zimbabwe do not tolerate. In fact, we urge authorities to punish. And where we can punish ourselves as traditional leaders, we do punish. Because physical violence or violence, be psychological, other forms of violence, in a typical culture that is functioning properly, in effect, domestic gender-based violence is an antithesis to the values of our culture. In Shona, which is the language I speak in Zimbabwe, we say, Mukadzi harogwi, you do not beat your wife. There's a saying like that. And this is very true. Very true. Every culture, real culture, not bastardized cultures, do not promote, do not support GBV. And I'm prepared to appear at any forum across the continent and argue and demonstrate that that's not correct. But some people have pointed to certain cultural practices, and I cannot boast that all of them in Zimbabwe are practiced in Zimbabwe. So those are that I know. For example, some of it, there's a problem when you talk of culture and gender-based violence. Some people are factual, and we accept that. Some people, it's more of a perception. Perception. For example, dowry or lobola, we call it. You are aware that across Africa, there have been movements who say, because you pay, when you marry, you pay something. Then you have the attitude that I've bought this woman. I'm therefore entitled to kick, hit as you like. I think maybe now I address the Secretary General. Madam Secretary General, I think this is a topic that you may want to explore further, and we are willing to engage further. There has been a bit of what I may call illicit views about some cultural practices, including lobola. Some perceptions are Western-based, and that is not supported. In fact, we're taking too long. About 7 years ago now, I think, about 7, 8 years ago, there was a case in Uganda. An NGO called Mikumi petitioned the appeal court, arguing that lobola, or payment of law dowry on marriage, should be abolished because it encourages gender-based violence. In short, the Supreme Court or Court of Appeal had 5 judges who heard the case. 4 were female, 1 was male. The 4 female disagreed with that application, that the payment of dowry encourages gender-based violence. The 4 female judges said no. The 1 male judge said, yes, let's abolish. So because the 1 male judge was the minority, the case did not succeed. But one of the most important arguments that came out in that case was researches have been done around across the world, and it has been found that countries like Bangladesh, if I remember, Philippines and the like, had the highest incidences of gender-based violence. But when they marry, men marry, when they marry, there's no dowry that is paid in those societies. There's no dowry paid, but still they record the highest. So there's no direct correlation between payment of lobola and gender-based violence. Let me move on. That's this issue of culture sometimes, as I said, it's much about perception and attitudes. Then the issue of, I just read in the document that victims and survivors sometimes have little or no access to justice system. Madam Secretary General, Segoma, please, I think let's contextualize these things properly. Where is this victim? Where is this survivor? Where are they surviving? Where do they reside? If they are in rural areas, there is no dearth of or absence of leadership in rural areas. Every corner, within a distance of 1 kilometer at least, there is some traditional authority who has mandate to deal with complaints and even enforce judgments. But let's also look at the issue that the issues of gender-based violence in most jurisdictions, if not all, including Zimbabwe, these are classified as criminal cases. Because they are criminal cases, except Botswana, where I know the traditional leaders enjoy some limited criminal jurisdiction, many of which relate to livestock. The jurisdiction of the traditional leaders is ousted. They have no jurisdiction on any case that sounds criminal or categorized criminal. Now, that's one issue. We are not saying give us those powers. Maybe there are good reasons why they are not given these. But look, the traditional leaders can watch. At the end of the day, you refer the matter to the police. And then you wait and you just watch, see how it will be handled, they concluded, what judgment. So the issue that traditional leaders also have no jurisdiction on a typical case of gender-based violence, especially when there's been harm caused. Yes, we can deal with other less harmful cases. And we do deal with those. And we ensure that we protect the victims. And the issue of access actually is there. But it's a question of the degree of harm, if it has been physical. And in most cases, the degree of harm is quite severe. And then you bring out the authority then has to go out. Let me conclude two issues at the end of the days. I think what we should focus more on is not whether culture or religion causes GBV, but it's the role. That's more important. What is the role of cultural authorities, traditional authorities? What's their role? Give them their proper roles. They're going to say, this is your role. Why are you not doing this? The issue of fighting and accusations about you are causing this, you are causing this, I think it has not yielded good results. But to say, you traditional leaders, in the next meeting, Madam Secretary General, SADC GBV, we have to agree on what are the roles of traditional leaders, and they have to be endorsed by traditional leaders. Are you performing your functions with regard to this? Then we start winning. Then we assign responsibility to religious leaders. What are your roles? Lastly, the issue of evaluating laws. Because there's a whole list, if you look from UN conventions to African Union to SADC to national laws on GBV. The laws, it's not about my absence of laws. It's more about to what extent have those laws been understood, accepted, synchronized, and enforced. So let's evaluate these things from time to time and critically look at every clause that we agree on and say, has this been working? So is the agreement after every 5 years, 10 years, we say, let's meet again and say, is this particular one working? Why is this one not working? Thank you very much, Mr. Moderator. I rest my case here.
Thank you very much, Senator Chief Charumbira, for those observations. Quite interesting. And what becomes apparent is the relevance of the model law. And for SADC GBV, this is very important, and it sets the stage for further engagement as we seek to domesticate. I will not preempt the responses because my responsibility is not to give responses. Let me allow Madame Sonda to respond.
Thank you so much, Mr. Moderator, and thank you for the very useful contributions that have come from the floor. I must say again that we've had a lot of comments, I think useful comments, that the rapporteurs are taking note, and shall be taken into account as the model law is being finalized. But to comment on some of the questions, the first contribution regarding the technicalities of the law from Honorable Theogene, I think. I hope I got the name right. I think he raised basically two issues. The one on sentencing policy, and he had a question that how does the model law treat the competence of the judges of the SADC member states in terms of sentencing. I must indicate, perhaps we need to, because he was talking technicalities, I suppose we should begin with the explanation that the SADC Parliamentary Forum is not a lawmaking body. So the work, the resolutions of the forum currently, perhaps that will change in the future, are not binding. They are not laws properly so called. So no, the model law is not a treaty. It doesn't have the status of a treaty. It is soft law. And I think in the beginning of the presentation, I did say that it is a standard, a benchmark that wishes to create a commonality of understanding and a commonality of standard, a standard system, which member states can then draw upon in their national legislative systems. So because of that, the model law, once it's adopted, it's not a treaty, so there will be no signature to say that the member states have signed up to the model law, but it will then be disseminated as a standard, which the member states in their domestic environments can then draw upon and to help them to fill the gaps in their own legislation, the domestic legislation. So in terms of the treatment of competence of judges, this is entirely domestic. This is based on the domestic legislation, and I suppose competence goes to how judges are appointed or selected. So all that is done at the domestic level. What the model law does in terms of sentencing is simply to provide some basic standards of what kind of sentencing policies national member states, SADC member states could adopt. And it's entirely up to the member states through their, and I think it did explain, and I had explained in the presentation also regarding the monist and dualist systems, and the SADC member states are a diversity, so they have there are monist systems and there are also dualist systems. But it's entirely up to member states to actually pick up certain principles or standards that are set in the model law and then pass them into their domestic law through their national process, the domestic process. It's not that once it's adopted by the SADC Parliamentary Forum, it immediately becomes binding or it becomes law in the member states. No, there will then be a process of dissemination. It's just to agree on a commonality of standards, which the member states can draw upon in improving where they have existing laws, or for those that do not have existing laws dealing with gender-based violence, to actually start thinking about and enacting laws dealing with gender-based violence. So the judges and their competencies as regards sentencing are entirely a domestic matter that the national member states should deal with. I think I've also dealt with the issue of how do member states adapt or adopt the model law. I think I've said each member state will, once the model law is passed, there will be dissemination. They will look at it and they will be encouraged to pick from there the standards which will help them to close the gaps in their own domestic legislation, or even to adopt it as a whole if they maybe don't have existing legislation. So it doesn't, the model law does not have the status of a treaty. It does not have that kind of status. Then there was the issue of evaluation of the legislative landscape in relation to the model law before the standards could be set. And I think I did say also in the presentation that such a study was, in fact, the research was undertaken, and it's on that basis that some of the provisions in the model law have actually been developed, because there was an understanding of the existing legislative landscape in the SADC region. I think the second speaker mostly made comments, which I appreciated, and that traditional leaders are agents of positive behavior change, and that there's no law or customary practices that should be used to justify violence against women or gender-based violence, and that the traditional leaders would want to work with the SADC Parliamentary Forum towards the development of the region and, of course, elimination of gender-based violence. The last honorable speaker also made comments, which I found useful, but one question that I got clearly from him was that was as to whether we are sure that the passing of the model law will eliminate GBV, or that is the problem legislation. I think that gender-based violence is caused by a multiplicity of issues. It's underlain by a multiplicity of issues. But the SADC Parliamentary Forum, of course, discusses gender-based violence generally, and what policies and measures, interventions can be undertaken to help prevent or eliminate gender-based violence. But this particular activity is, the SADC Parliamentary Forum is an association of legislators. So they're actually looking at one of the most important tools that the legislator has is the law. So in this case, the SADC Parliamentary Forum decided that they could try and assist SADC member states to strengthen their legislative instruments through the development of standards which are contained in this model law. So this could just be one. Obviously, it may not be the panacea to all the challenges relating to GBV, but it's an important, legislation is an important one because it creates a framework within which all other activities and actors can meet and try to resolve the existing problem. So far be it from the forum to claim that this is the be or end all and this will be the solution to all the problems, but it is, the legislation is an important tool. It's a governance tool which can assist to ameliorate or even to create an environment in which other measures and other interventions can also be undertaken once there's that backing of the law. So further engagement on cultural practices which are perceived to be negative. Yes, I think those have been taken note of, that there should be further engagement with the traditional leaders, and especially to analyze certain traditional practices and the payment of dowry, I think was given as an example, and a case in Uganda. Yes, so I think the rest of there were comments, perhaps SG would like to comment. Mr. Moderator? For me, I think I'll end there. Thank you.
Thank you very much, Madam Sonda, for the responses. At this juncture, let me invite the Secretary General, in case she wishes to make some comments. There were a few remarks and observations that were directed to the Secretary General. Over to you, SG.
Thank you, Director of Ceremonies. Thank you very much for all the interventions. Mine really is not to take away from what Ms. Musonda said. I don't think I have any comment at this point. Safe to say, the issues that have been directed for consideration to the SADC Parliamentary Forum have been noted. And at this point, just to emphasize that we are respectful of culture, we are products of culture, we are citizens of the region, children of the soil, daughters of the soil. We survive because of the protection that we've had growing up from our gatekeepers of culture. And therefore, if I may be quoted, I would like for the forum to be quoted as saying that all cultures are protected under the mainstay and development of the GBV SADC model law. In this regard, I'd like to appreciate you all and put on record also the appreciation of the leadership of women parliamentarians who caucused and actually put forward a motion to develop the SADC GBV model law. I thank you, Director of Ceremonies. Thank you.
Thank you, SG. You forgot to wear your other hat as an enforcer of culture. SG is from royalty, and so she's not just a product, but she's an embodiment of culture. Also, at this juncture, I also wish to put on record the appreciation made by Chief Fortune Charimbira, not just as the traditional leader, but also as the acting president of the Pan-African Parliament, of the extent of the reach of SADC-PF's consultations, in particular engaging traditional leaders and religious leaders. It was quite an effort on our end. It is not every day that we approach our traditional leaders this way, where we invite them to come and join us. We usually prefer going to them. So we also were reflecting quite a lot about the suitability of the methodology we were using, being on a virtual platform in the first place, and just making them Mohammed not going to the mountain, but asking the mountain to come to Mohammed. But we are happy that the traditional leaders are appreciating the gesture that SADC PF has made, and appreciating the richness in terms of the extent to which the consultations have been opened to a diversity of stakeholders. As we draw towards the conclusion of the meeting, I wish to check if there are any members or participants that wish to make further comments, questions. While we are doing that, I also wish to check with Professor Chitando if you are in the meeting and ready.
Yes, I am. Thank you.
Thank you very much. ICT, could we attend to the issues as agreed in terms of the mics? So at this juncture, I have the pleasure of inviting Professor Ezra Chitando from the World Council of Churches, Southern Africa, to deliver concluding and solidarity remarks. You have the floor, sir.
Thank you very much, moderator. Ladies and gentlemen, good afternoon. All protocols observed. Distinguished fellow participants, religious leaders and traditional leaders, it is my singular honor and privilege to give concluding and solidarity remarks on behalf of the World Council of Churches, the WCC. As the WCC, we are extremely grateful to the SADC Parliamentary Forum for recognizing and appreciating the strategic role of religious and traditional leaders in the development and implementation of the SADC Gender-Based Violence GBV model law. Such has been the level of engagement and commitment that one must fight the temptation to say, and I quote, "Let us remain here on this platform permanently," end of quote. Dear colleagues, we would not be the first ones to face this temptation. We read in Luke chapter 9, verses 32 to 33, that after an incredible experience on top of the mountain, Peter commented to Jesus that it was good that they were there and proposed building tents on top of the mountain. However, we are called upon to leave this mountain, this online platform, and return to our communities to continue our struggle against GBV. With this SADC GBV model law, our motivation has been intensified. As religious and traditional leaders, we would like to thank the SADC Parliamentary Forum for taking our role seriously. We are literally everywhere. That is, wherever one finds the people of God, one finds religious and traditional leaders. According to the Afrobarometer Dispatch number 339 of 2020, Africans trust their religious and traditional leaders more than any other category of leaders. We are on the front line, responding to cases of GBV when they happen, as well as seeking to provide effective counseling to prevent them from happening. We provide a permanent ministry of accompaniment to our communities. We take guidance from the Namibian proverb, which says, and I quote, "If the leader of a hunting party gets tired, all are tired," end of quote. We would like to reassure the SADC Parliamentary Forum of our unwavering commitment towards the goal of the model law. This is to promote gender equality, reduce gender discrimination, and prevent abuses and acts of violence which are related to gender. For example, the World Council of Churches, its member churches and community activists are promoting the Thursdays in Black campaign. Today is a Thursday. Today, like every Thursday, I'm dressed in black to call for a world without rape and violence, for a world of gender justice. The badge that I put on every Thursday says, I quote, Thursdays in black towards a world without rape and violence. As we come down from this mountain and away from this platform, we do so with a sense of renewed hope and optimism. We will do all in our power to mobilize our communities to uphold the model law and resist GBV. Inspired by the promise of our sacred texts, that we will not labor in vain and that we shall overcome, we will work towards gender justice. In our engagement, we will sit at the feet of women. We do not want anybody to strike a woman, but we are reminded by one of our regions and continent's outstanding daughters, namely Winnie Madikizela Mandela. She said, and I quote, when you strike a woman, you strike a rock, end of quote. Shoulder to shoulder with our daughters and sons, we will utilize the GBV model law and transform our homes, communities, nations, and the entire SADC region into oases of love, laughter, and warmth. Kala ponawa, ngiyabonga, zikomo, kiyaliboga, dolivua. I thank you. Over to you, moderator, and out.
Thank you very much, Tando, the Minister of Accompaniment. And shall we build the tents and stay on top of the mountain? You said no, we must conclude so that we go down the mountain and be able to do the work. Thank you very much for those well thought out, provoking, concluding remarks. We leave here motivated, as you said, with renewed hope that with the hand of our traditional leaders and religious leaders, we will be able to kick out gender-based violence from the SADC region. This leaves me with the task of thanking everyone most heartily for finding time to come and engage with the SADC Parliamentary Forum in this regard. As I said, our culture is to go to our Mrena and pay homage, not to invite them. But in circumstances where we are dictated by situations, we appreciate that you did not bother, that we did not follow the normal protocol, and you have been in the meeting and have been quite engaging. We appreciate. As promised by the Secretary General, the development of the model law is the beginning, not the end. And therefore, we shall continue to knock on your doors as we seek for the domestic process to make sure that the provisions of the model law find meaning and expression in the communities that you lead and live in. Thank you very much, Asante Sana, obrigado and merci. Have a good day. ICT advise if we need to put our videos on for the photo session. Modise? ICT and media, please advise.
Yes, I think we can have our videos on for a screenshot.
Sure. Honorable members, before we leave the meeting, shall we all put our videos on so that we see the blacks on Thursday and take photos before we leave? Professor Chitando, we want your video on. So
Thank you very much. For one reason, it says it failed to start the video camera.
ICT, please. Are you able to assist?
Yes, now it seems. Still, it's not.
Senator Nichombo. Pegishazo. Can we have our videos on, please? ICT, are you able to assist Professor Chitando?
I think it's on his side because I tried asking him to switch on, but it's still not going through.
Okay.
I think it's a technical hiccup, but I will send my beautiful self.
Okay. You advise us, ICT and media, when you are happy, and then we can conclude the meeting.
Okay, I'll be taking the first shot for the first round now. Perfect. All right. I think we are good. Thank you.
Thank you very much, Wilfred. And once more, thank you very much, everyone, and have a good day.
Thank you. Bye.
Bye. We can terminate. Magadi Seguru.